Amy, for the warm introduction, and thanks everyone for coming. We are really excited to be here today talking about AI in the legal landscape. As Amy mentioned, it seems like there's something new going on in this field just about every morning when I wake up. So we have a lot to cover, and we will dive in. Before we get to the substance, just brief introductions. I am Lynn Joyce. I'm a partner here at Keker along with Sarah, and Spencer also works with us here at Keker. My focus is on IP litigation with a mix of high stakes copyright, patent, and trade secret cases. I represent a significant AI company in several copyright cases across the US. Our presentation today will not focus too much on that case for confidentiality reasons, but we will talk about broader themes and issues that are applicable across the whole sector. Sarah, do you want to go next?
Sure. Like Katie Lynn said, I'm also a partner here at Keker, Van Nest and Peters, similarly with an an IP-focused practice, for me, primarily focused on trade secret and copyright matters. And I likewise work on that high-profile AI matter that Katie Lynn mentioned. Spencer, want to go next?
Yeah. Morning, everyone. I'm Spencer McManus. I'm an associate here at KVP. My work is complex commercial litigation, including some IP matters, including the matter that both Katie Lynn and Sarah mentioned already, in addition to some class action work as well. And we're looking forward to talking to you today.
Great. So for better or worse, there's a wealth of options when you're presented with an opportunity to talk about AI in the law. And I started in preparing for this presentation somewhat at a loss for where to even begin. And I turned to my good friend ChatGPT and asked it, what were the top 3 legal AI developments in 2024 described in less than 20 words? And you can see on the screen the answers I got back. The first is lawsuits over AI training, copyrighted data. Second is global AI regulations, including the EU AI Act. And the third is AI-powered legal tools revolutionized law practices. And I thought, wow, that actually sounds like a really fun presentation. And we have used it largely to frame our presentation today. But I didn't think just a text prompt was enough. So I decided to instead say, how about you show me it in a picture? And this is what ChatGPT returned back. And I think really illustrates how quickly this technology is progressing in terms of you start with text and now we have these amazing, rich, high quality pictures that can be turned out within seconds of asking a model to do it. But that still wasn't enough. So then I asked it, can you make this presentation into a short video? And I entered the prompt into Sora, which OpenAI just launched at the end of last year. And this is what I got back. There's no audio. It does not have sound, but it really is just so astonishing how quickly these tools have developed and are changing the world all around us. So with that background in mind, here's what we'll cover. We'll cover basically everything that ChatGPT told us we should, which is first, we'll start with a very brief introduction to artificial intelligence and machine learning. We will talk about AI regulations and focus on some of the really big ones that have emerged globally, as well as some interesting state regulations that we're seeing. We will talk about major developments in private litigation, what claims are being brought, what we see is on the horizon. And then we'll conclude by talking about something very practical for everyone on this call, which is how do we use and safely use AI tools in our legal practice? Because they have all these benefits, but they also have a number of risks associated with that. So starting with a very, very brief overview of the technology, I would suspect that there is a really wide range of familiarity with AI technology in this call. But at its core, I think about it this way. I think about AI as a set of analytical approaches to problem solving, which includes natural language processing and machine learning. But instead of happening inside the human brain, it happens in computers. At its core, it really is just solving problems. Generative AI is a term that many of you have, I'm sure, seen at least in the news, if not in your profession. And that is a system, an artificial intelligence system that is capable of generating new content. That could be text, it could be images, it could be sound, video, or something, code, anything else. Like the slides that I just showed you from ChatGPT, where I entered a prompt and the model responded with first in text and then a picture and then a video. That was all made using the technology that's referred to as generative AI. It created new content when I submitted my request. One type of generative AI, you can go to the next slide, Spencer, is what's called a large language model. It's also referred to as an LLM. And these models, what they do at their core is they predict text. So if you input a prompt into an LLM that starts with Paris is a city in ... the LLM can then finish that sentence using probabilities and relationships that have been baked into the model. This image, by the way, is from it is still from a video series on AI and neural networks that was produced by 3 Blue, 1 Brown. And I'm giving a little plug for that. I have no affiliation with 3 Blue, 1 Brown, but I found this series to be incredibly useful if you're interested in learning more about how this technology works. The videos were very accessible to people like myself who do not have a technology degree or background. So that's LLMs. That's how they work, but how are they developed? This is another thing that frankly could be an entire CLE in itself. But I turned to ChatGPT to summarize how are LLMs developed in 3 simple steps. And those steps boil down to their core are first gathering data, which means that to train an LLM, you have to collect a really big amount of text data from sources to teach the model about language and about relationships between words and parts of words. The second step after you have gathered the data is to actually do the training. And you feed the data into these computers, and the computers then go through a process of adjusting what are called weights, which signify sort of the relationship between different pieces of words. And you feed in all this data, and it's constantly adapting to the additional data that you give it. And that process is called training. And then the last part of it is the deployment and improvement, which is just putting the model out in the world, gathering feedback from people who actually use the model, and then using that feedback to make the model even better and even more useful. I also like how on ChatGPT, you can see here how it ends the response with short, sweet, and to the point. I found that it's a very encouraging sort of LLM. There's one other sort of major type of model. We talked about generative AI models. The other sort of big category of models is what's called diffusion models, and they work differently. The way that they work is that you start with clean data, like this really clear picture in the upper left-hand corner. And the data is then destructed by adding a lot of noise. The model then is asked to find its way back to a clean image. And through that process of adding noise and removing noise, the model learns how to render clean images. So diffusion models are often relied upon when an entity is interested in making models that can generate really high quality images and texts. So that was AI in like, I don't know, 5 minutes. And I hope it's helpful. And I understand many of you may have deeper and more familiarity with the technology. And if you have additional questions, we're happy to answer them along the way or at the end. But otherwise, I will turn it over to Sarah.
So as Amy alluded to at the beginning of the call, the legal and regulatory landscape for AI is fast evolving, and it wouldn't be practical to cover every single regulation in this call. But what we'll do is try and cover at a high level some key regulations and laws globally, and then also some with respect to California, Colorado, and Utah, some key states. So starting with the European Union, on August 1st, 2024, the European Union's AI Intelligence Act came into effect, which establishes a common regulatory framework for all EU members. And the EU AI Act takes a risk-based approach to categorizing AI systems. In total, there are 4 levels of risk. The first is unacceptable, in which case the AI use would be prohibited. The second is high risk, in which case the AI system is permissible, but only with a high level of regulation and extensive requirements. The third is limited risk, which triggers only transparency requirements. And the fourth is minimal risk, at which case there wouldn't be any kind of regulation obligations triggered under the Act. So some examples of prohibited AI uses under the EU AI Act include AI applications that manipulate human behavior, such as attempting to manipulate who to vote for, or voice-activated toys that encourage children to do dangerous things, which sounds terrifying. Those that use real-time remote biometric information, such as facial recognition in public spaces, and those used for social scoring. In other words, ranking individuals based on their personal characteristics, their socioeconomic status, or behaviors. In the category of high-risk uses, which the EU AI Act defines as systems with the potential to cause significant harm to EU citizens or the environment, sits AI uses in critical infrastructure, such as transportation, healthcare, and in decision-making processes with legal implications. So that might include AI uses in credit scoring or in hiring decisions. High-risk AI providers must establish a risk management system for their product for the life cycle of that product or system. They have to conduct extensive data governance and reporting, and they must also design their AI systems in such a way that those using it could find information about how that AI system works, evaluate its functionality, and comprehend its strengths, limitations, and risks. In the category of limited risk AI systems sit things like chatbots, AI that interacts directly with individuals, or which generates synthetic audio, image, or text content. And in that bucket, the EU AI Act imposes significant transparency requirements. So to the extent that an AI user is receiving synthetic outputs, it must be in a machine-readable format where it would be detectable that the output is artificially generated or manipulated. To be clear, the vast majority so far of AI systems implemented in the EU fall into that minimal risk system bucket, the final one, where there is not regulation or requirements under the EU AI Act. And those minimal risk systems include things such as video games, AI-enabled video games, spam filters, things of that nature. The enforcement fines under the EU AI Act are quite steep, and penalties for violations can range from $35 million or 7% of annual global revenue for the AI system maker. The Act additionally grants individuals in the EU the right to complain if they believe that the AI system has caused them harm, and to potentially receive an explanation about why that AI company made certain decisions. Turning now to, we can do the next slide, thank you. In China, it's not like the EU in that there's not a one comprehensive system or body of law or regulation, but rather AI in China is regulated by a set of overlapping measures. The first of which is the generative AI measures, which China issued in July 2023. And the generative AI measures, it's important to note, apply to generative AI services offered to the public in China, regardless of whether the generative AI service provider is based within or outside China. So to the extent that you're a provider that's not a Chinese company or doesn't reside in China, to the extent that you want to provide AI services to the Chinese public, you would still be regulated by these measures. And without going into exhaustive detail, the main goals of the generative AI measures are a focus on the privacy of pre-training data, and also on content screening. The deep synthesis provisions are intended specifically to regulate the use of algorithms to synthetically generate or alter online content, which includes video, voices, texts, and images. And the goal there is to improve standardized management of algorithmic recommendations and to monitor the use of deepfakes. The ethical review measures, in fact, apply to all scientific and technological development in China, and so that includes AI development, and requires that any AI company that is establishing or developing an ethically sensitive product create an internal review committee to monitor the ethical implications. And it's a little bit vague from the regulations what an ethically sensitive product might be, but one definition is that it's one that could influence public opinion or shape social consciousness. And finally, the algorithm recommendation provisions require that a service provider that is capable of influencing public opinion or driving social engagement file their algorithm with the Cyber Administration of China within 10 working days after the provision of the services. So turning now to the United States, unlike in the EU and in China to some extent, there's no comprehensive federal legislation or regulations in the US that govern AI. That said, there are more than 120 AI bills that have been introduced in the US Congress, and those bills cover a wide range of issues such as AI education, copyright disclosure, robocalls, biological risk, and AI's role in national security, which I think should be on the top of all of our minds. And ultimately, lawmakers in the United States have taken a cautious approach to regulation in order to foster innovation. There are a lot of concerns about stifling technological progress here, and we want to maintain competitiveness, particularly against countries like China. As for Canada, The Artificial Intelligence and Data Act was first introduced in June 2022, and this act is similar in form to the EU AI Act in that it categorizes AI services according to risk and accordingly provides regulations based on those risk assessments. However, the AIDA has been slow to come out of committee. It has not yet passed committee, and it remains unclear whether it will in fact do so prior to the deadline of October 20th, 2025. And if it does not do so, the next government would then have to reintroduce it. So I think at this point, we'll turn to a state overview.
So I'll talk about a few different states, and then the Copyright Office and the current administration and their approach to artificial intelligence. So starting with California, there have been almost 24 AI-focused bills that have been passed in California over the last few years, many of which are in effect already, but some of which will be coming into effect next January. Starting with AB 2885, it recently created a standardized definition of artificial intelligence, and it defined artificial intelligence as an engineered or machine-based system that varies in its level of autonomy and that can, for explicit or implicit objectives, infer from the input it receives how to generate outputs that can influence physical or virtual environments. So as you can see, a very broad definition, but a universal one nevertheless in California law. A number of these individual bills have regulated a number of different areas, including voice and likeness, election integrity, platform transparency, protection from sexual exploitation, and then some vetoed bills as well. So we'll briefly talk about each of these. Starting with voice or likeness, AB 1836 recently regulated digital replicas, including replicas of deceased personalities, and contain restrictions on when those replicas are allowed to be used and disclosure requirements around them. Another big area is election integrity. There have been a number of bills focused on this in California, largely aimed at deceptive advertising and political communications. So just to focus on a few of them, AB 2839 prohibited the distribution of misleading AI-generated political communications in the time period around elections. And it additionally required disclosure if AI was used to portray candidates doing something that didn't happen or that they didn't actually do in real life. A number of these bills aimed at deceptive advertising and particularly political communications are being challenged in the courts. There are two prominent challenges currently making their way through the California courts as to these, both targeted at AB 2839 and a similar bill, AB 2655, which regulated the deceptive advertising I mentioned. First is a challenge by X and a few of its users. One of those users is a person who had a Twitter account that created a deepfake video of Vice President Harris during the last election. They sued to block AB 2655 and AB 2839 just days after Governor Newsom signed them into law, arguing that they violate the First and 14th Amendments of the Constitution and a provision of the California Constitution. Similarly, the Babylon Bee, which is a conservative satire outlet, much like The Onion, and some bloggers have challenged the two bills on the grounds that they violate the First Amendment. Those cases are currently in summary judgment briefing, so we should be expecting a ruling soon, and if the motions aren't granted, they'll be proceeding to trial. Moving on to platform transparency, these bills are quite broad in what they require: disclosure of the materials used to train different models, identification of where content has been generated by AI, especially in particular contexts like healthcare through SB 942 and AB 3030. And then also making clear how consumers can get in touch with humans in the consumer rights area. I'm sure many of us have encountered AI chatbots or AI phone bots when you call customer service lines. There are requirements in California, both currently in effect and going into effect next year, that make clear or require companies to make clear when they are talking to AI entities and informing the consumers how they can get in touch with a real customer service representative. Moving on to protection from sexual exploitation, there are a number of bills in this category as well, including some that have criminal consequences for violations. The first is SB 981, which required platforms to implement mechanisms for California users to report digital identity theft that's sexually explicit. And then SB 926, which instituted criminal penalties for violating these various sexual exploitation protection laws. It includes criminal consequences for creating or distributing AI-generated sexually explicit deepfake content, where the person distributing the content knows or should know that the distribution of the image would cause serious emotional distress. There's also additional laws in the consumer privacy area, amending the definition of personal information under the California Consumer Privacy Act to include abstract digital formats, including AI systems that contain or could output personal information. I mentioned the vetoed bill earlier. That was SB 1047. That would have required implementation of several different control mechanisms that aim at preventing critical harms. It also imposed testing and reporting and audit requirements and obligations on these companies. And it contained additional whistleblower protections for employees of companies developing these AI systems. It would have imposed pretty significant penalties for violation of the law, up to 10% of the cost of the computing power to train the covered models, which for some of these models can range into the millions or potentially billions of dollars. But Governor Newsom vetoed that law last year, and it has not been passed over his veto. So very briefly on two other states that are sort of in the lead on these issues. Both Colorado and Utah have enacted artificial intelligence acts. The Colorado Act goes into effect in February of next year, and the Utah Artificial Intelligence Act is currently in effect. I'm going to focus on Colorado. The Colorado AI Act creates duties for developers and for those that deploy artificial intelligence. Unlike some other state privacy laws, like some of the California laws that I mentioned earlier, there isn't any revenue threshold for applicability, so it applies to all developers and deployers of certain types of AI risks or high-risk AI systems in Colorado. The Colorado Act focuses on automated decision-making systems and high-risk AI systems at that, which include those that when deployed make or are substantial factors in making consequential decisions. And consequential decision is also defined under the Act. It includes things like employment opportunities, lending, essential government services, healthcare, housing, insurance, and importantly for all of us, the provision of legal services. The Act also focuses on bias and discrimination. And so developers and deployers must take reasonable care to avoid discrimination via these AI systems, where they are a substantial factor in making one of the consequential decisions that I mentioned above. So moving on to the Copyright Office. The Copyright Office has been confronting the issue of authorship in the AI context. If AI can't be the author or the inventor of something, that leaves open the question of whether the humans who use the artificial intelligence services can secure IP rights for their creations that they made using the assistance of artificial intelligence. This question arose in this case with a comic book called Zarya of the Dawn. This person used Midjourney to generate images for her content, or for her comic book rather. And parts of those works were generated by Midjourney, but it was also mixed with her own creative content. The Copyright Office refused to register the works that contained material generated by Midjourney, and it held that text prompts used to generate these images through the artificial intelligence service, even detailed ones, were not sufficient for human authorship because the output wasn't predictable and wasn't controlled by the artist. It left open the issue of whether copyright protection could apply for the selection or arrangement of the works that were generated by artificial intelligence. About 2 years ago, the Copyright Office issued guidance expanding on this ruling, and it again left open the possibility that some AI-generated works might be protectable, but it didn't provide any specific explanation or examples of what sufficient human input on those works might mean. But sort of overall, it made clear that works that were generated by AI systems solely in response to user prompts are not copyrightable. In those 2 intervening years, there hasn't been much additional clarity on what sufficient human authorship means, and this issue hasn't really been tested in courts. The general idea of sufficient human authorship was blessed by at least one court in the District of Columbia in the case Thaler versus Perlmutter, which is cited there on the slide. In that case, the court declared that human authorship is the bedrock requirement of copyright in the August 2023 decision that affirmed the Copyright Office's denials of registration for works that didn't claim any human authorship at all. So again, the issue of what sufficient human authorship is for the boundaries of copyrightability has not really been tested in the US courts, in the US federal courts, that is, as applied to the Copyright Act. Just very briefly, it's worth noting that international approaches, including some of the ones that Sarah was talking about, diverge significantly in this area. In particular, in November 2023, the Beijing Internet Court came to the opposite conclusion under Chinese law about whether AI-generated images are copyrightable, ruling that they are, and finding that a defendant who had reproduced AI-generated images without permission was liable for copyright infringement. About a year ago, in another Chinese case, a different AI company was found to have infringed the copyright of a Japanese superhero called Ultraman, specifically because the images generated by the AI service were substantially similar to the original character that was generated by humans. As Sarah mentioned, these issues highlight China's different approach to AI-generated works, and in particular, there are other laws that they've passed that expose companies to potential infringement liability, in contrast to what US courts have found so far. So the new administration has been taking some different approaches to AI, especially as compared to the prior administration. On his second day in office, President Trump brought the CEOs of OpenAI, SoftBank, and Oracle to a press conference announced Stargate, which is a $500 million AI infrastructure project. A lot of details about the program are not clear at the present, but what is clear is that the administration is promising up to 20 large AI data centers in the United States, some of which are already under construction. The precise contours of the program are going to be rolling out gradually according to the administration, and so we'll see where that goes. The president also issued 2 executive orders early in his administration regarding AI. The first one revoked an expansive Biden-era executive order that was issued just before he left office. That executive order had directed development of best practices and guidelines for AI development throughout the federal government. It also directed the Department of Energy and certain technology task forces within the government to institute reporting and disclosure requirements for certain types of models and computing clusters. It also required cybersecurity risk assessments for critical infrastructure, financial systems, and defense programs using artificial intelligence, and established task forces for evaluating AI uses in healthcare, life sciences, and to promote privacy, equity, and civil rights in the use of artificial intelligence. The president revoked that executive order a few days into office and replaced it with Executive Order 14179, which continued some of the deregulatory themes that the administration showed in revoking the Biden executive order. The new executive order was titled Removing Barriers to American Leadership in Artificial Intelligence, and it directed several government agencies to evaluate their regulations and how they could be curtailed or repealed to accomplish what the administration said would result in additional progress and quicker progress in artificial intelligence. AI companies have been taking somewhat different approaches to dealing with the government under this new administration as they had in the past. As many of us might remember, in the Biden administration, the artificial intelligence companies had been working with the administration to institute some of these protections, including those that Executive Order 14178 repealed. In this new administration, the companies are taking a different approach and are asking for a lot of deregulation. One area in which this is pretty evident is regarding the Biden era AI chip rules that are about to go into effect in May. There's a May 15th, 2025 compliance deadline to comply with the Framework for Artificial Intelligence Diffusion, which aimed to control the export of advanced semiconductors from the United States that are used in many AI applications. Companies like Oracle, NVIDIA, and Microsoft are asking the new administration to scrap or revise these rules and draft regulations out of the fear that Chinese companies would fill the gap and start gaining an advantage in the physical hardware that's needed to run many of these artificial intelligence programs. And that's just one example of the different approach that these companies are taking under the new administration.
We'll now talk about major developments in private litigation, and this is another area where there is just a tremendous amount of material that we could cover. Big picture on the next slide, we've seen just a tremendous amount of growth in the number of lawsuits against AI companies. And these lawsuits are really on the forefront of legal issues that have been largely untested, are based on new theories, and where we don't have guidance yet from appellate or the Supreme Court. There is a bunch of different flavors of lawsuits, and we'll touch on a number of these, but there's even more on the horizon. So we will hit some of the big ones and the ones that we are seeing repeatedly. And those include copyright and the DMCA, which is also known as the Digital Millennium Copyright Act, trademark, right of publicity, invasion of privacy, and then an overview of other federal and state law claims. On the copyright front, litigation against AI companies has just exploded over the past year. Nearly every major generative AI company has been pulled into these fights. You can see on this slide, Microsoft, OpenAI, Stability AI, Runway, Meta, Google, Anthropic, they're all getting dragged into court on copyright claims. The fact patterns of these cases are all different, as is expected, but a lot of the cases follow a pattern of accusing the AI company for copyright violations based on the AI company's training of the models using copyrighted works. Some plaintiffs also point to the outputs, which is what the model spits back to the user, as alleged infringement. They say that the AI models are reproducing their copyrighted works in what they deliver. So it depends again on which case you're looking at, but by and large, the theories are either a training theory or an output theory. In both circumstances, the main defense that we're seeing across these cases is fair use, which it rises under section 107, the copyright. It's a complex multi-factor test that we could talk about in a whole other CLE. But if you're interested in this, this is actively playing out right now in 2 cases in NDCal. The first is the Meta case, which is a class action of book authors suing Meta for alleged copyright infringement and related claims, largely related to Meta's use of books when training Llama, which is Meta's model. The case is pending before Judge Chabria, and plaintiffs filed their partial motion for summary judgment a couple weeks ago, and Meta just 2 days ago filed their opposition, and the briefs are competing as to their cross motions on the issue of fair use. The hearing is set for May 1st. And then the other case to keep an eye on, if you're interested in digging into this, is the Bart's v. Anthropic case, which is pending before Judge Alsup. The summary judgment motions are due tomorrow in that case, and the hearing will likely be set in May as well. So we're just, this is all happening right now. There's a ton of activity, and there's certainly going to be articles and news about those 2 cases over the next month or so. Another related claim that we see frequently in the cases being brought by plaintiffs against AI companies is DMCA claims. And the DMCA defines something called copyright management information. And you can think of it as the information that tells the public who owns a copyright in this work, like the name, the title, does it have a copyright symbol, information like that. And the DMCA tells us that you cannot intentionally remove copyright management information, knowing that the removal will induce, enable, facilitate, or conceal copyright infringement. The idea is that you can't take something, remove the copyright management information, knowing that that's going to make it more likely to be reproduced and infringed by other people. The claims against AI companies have alleged that the copyright management information, such as author name and title, is removed in training and is also not included in the outputs. Because of the certain requirements in the DMCA, including standing and the double scienter requirement, many of these claims have been largely unsuccessful on motions to dismiss, but the courts have not taken a consistent approach, and there's a dispute across jurisdictions and individual judges even as to how these claims will fare in the long run.
So as Katie-Lynn has pointed out, by and large, we're seeing copyright infringement and DMCA claims and suits against AI companies. However, there have been a bevy of other theories that we're seeing proliferate. So for example, certain plaintiffs have alleged trademark violations based on AI outputs. And one such example of a case is the suit brought by stock photo provider Getty Images against the artificial intelligence company Stable AI Inc., accusing it of misusing more than 12 million Getty photos to train its Stable Diffusion AI image generation system. And so if you look at the slide, we have here reproduced 2 photos from the Getty complaint. The photo on the left is the Getty Images photo as you can find it in their database. And then the photo on the right, which has some truly upsetting contortions of the human body. I never want to see a foot going that way. Is a version of that image as outputted by Stable Diffusion's image generation system. And what Getty has said, amongst other things, is that the inclusion of that watermark on the output creates confusion as to who actually owns the original image, and also causes trademark dilution by associating that Getty mark with a low quality image. There's been no ruling on this issue yet, so TBD where the court will fall on that. Next case we want to cover relates to the right of publicity. So plaintiffs have sued AI companies, alleging that those companies have used their likeness without permission for purposes of selling subscriptions or services. And one such lawsuit was brought by in April 2023 by Kylan Young, who is a reality TV star, or at least is one according to folks who watch Big Brother. And Mr. Young filed a putative class action complaint in the Central District of California against software developer Neocortex Inc. And so what Neocortex service Reface does, as you can see here on the slide, is it allows the user to become anyone that they want. You can swap your face with celebrities such as Johnny Depp or Frida Kahlo or Kylan Young, if that's something that you're interested in. And in response to Mr. Young's suit, Neocortex filed an anti-SLAPP motion to dismiss the complaint and also asserted that his claims were preempted by the Federal Copyright Act. Neocortex further asserted that its use of Mr. Young's image was transformative because the photos were sufficiently altered so as to be protected by the First Amendment as a matter of law. The district court denied that motion and largely rejected Neocortex's argument in a ruling that was ultimately affirmed by the Ninth Circuit in 2024. Turning now to invasion of privacy, plaintiffs, in a similar vein to the case that we just covered, plaintiffs have also filed invasion of privacy lawsuits, again relying on state law privacy statutes. And a fairly well-known case or example of that is a lawsuit filed against facial recognition startup Clearview AI by a class of Illinois citizens. And so Clearview AI builds tracking and surveillance tools using facial recognition technology. And what the class asserted was that Clearview, which scrapes billions of Americans' facial images from the web and sells them, did so without the individual's consent, and so violated the Illinois Biometric Privacy Act. This case very recently reached a settlement, and it's a unique settlement that gives plaintiffs and their lawyers a stake in Clearview's future value instead of a lump sum payment. If we could go to the next slide. Really, what we've covered here is the tip of the iceberg. We've seen some flavors of claims, but we anticipate that there will be more to come. Folks may bring, for example, breach of contract suits based on the use of data in excess of, contractual allowances to train models. There could be CFAA claims based on the AI company's use of plugins or scraping tools to obtain third-party data from websites. And claims will abound, we anticipate, under state law, competition, and consumer protection laws. At the end of the day, however, as we sit here today, most of the defenses and claims that Katie and Lynn and I covered remain largely untested. We don't have rulings from many courts yet. And without broad federal legislation or law or regulation, the law governing AI will largely be made in the courts. There's also a potential, as of now, the plaintiff's bar has focused on AI companies, but that may yet expand, and that focus may turn to downstream users of those AI services. It's something to watch, and we'll be considering.
Thanks, Sarah. So last section here, using AI in your legal practice and what do you need to think about if you're interested in that. There is so much potential in the realm of AI tools for legal work. This list is not comprehensive, but it's the low-hanging fruit of what comes to mind when I imagine how could these tools apply and improve my legal practice. Legal research, document review, summarization. Could it do fact research and investigation? Can it help us predict risk? That starts to get a little, scary, but drafting pleadings, there's so many possibilities for this technology, but there's also a lot of concerns and risks given the nascent nature of it and the way that the technology works. Individual practitioners are not the only ones thinking about AI usage. We've also, over the last year, seen the bench thinking about AI tools. And on an individual level, some judges are experimenting with how AI tools can streamline their work. Judge Newsom on the 11th Circuit made headlines last year by using ChatGPT and 2 other LLMs as part of his analysis for a case. He was considering the ordinary meaning of the phrase physically restrained, which is a term that had been invoked for application of a sentencing enhancement. And he actually asked the LLMs, what is the ordinary meaning of physically restrained? And he used the response as part of his analysis for what that phrase should mean. On a broader court-wide level, we have also seen the 9th and 3rd Circuits set up AI committees with the goal of taking a more measured approach to AI use. The 2024 Federal Judicial Conference devoted 3 hours to discussing AI-related issues. They had 8 experts present to them. So there's a lot going on here, and we certainly can and should expect AI to play a role in our practice, but it's going to come with some hitches. The could you go back just one slide, please? Thanks. Oh, sorry, next slide. I thought it skipped that. There you go. So why these hitches are needed, there's some really serious risks to using AI in legal work. I'm sure you all have seen the stories in the news of lawyers who have drafted a beautiful brief and they found a seemingly perfect citation to a case, and it turns out that that case is just completely fabricated by an AI tool and does not stand for the proposition that it was cited for. And so none of us want to be in that position of having filed a brief that does not include a real case. And it can look very legitimate because these AI tools are great at predicting text, but the case might be non-existent. And so we really need to be cautious when we approach using tools, especially in our practice. There's one other sort of major risk area for using AI tools, which is that the information that you actually input as a prompt into chatbots may not stay confidential. And you can see here on the terms for Google AI, they say, we don't want a reviewer, that reviewers can see and use your prompts to improve Google's products. And that not only allows, leaking of confidential information to a third-party company, but if a tool is trained on it, then there's downstream risks to how that tool could function and possibly rely on information, confidential information that you would put into it down the line.
So, what has the California bar said in light of the risks that Katie Lynn just highlighted? The California bar has issued some very practical guidelines on AI use and technology that I encourage anybody considering such use to read. It's 3 pages. It's very clear. And although it's not explicitly incorporated into the rules of professional conduct or the State Bar Act, it provides helpful guidance in how to consider your pre-existing duties as they apply in the world of AI. So if we could go to the next slide. First and foremost, we have a duty of confidentiality, of course, to our clients. And to the extent that you're inputting information into a generative AI product, including prompts, including uploaded documents or other resources, that generative AI service might retain the right to train its own models on what you've inputted. It might also retain the right to share that query or data with a third party, or to use it for other purposes. And even if the AI product or service does not utilize or share inputted information, it may lack the reasonable and adequate security measures that we as lawyers need to have in place when we are dealing with clients' sensitive data. So, to the extent that you're using AI to supplement your legal work, you should not be inputting any confidential information about your clients into the AI product or service. And to the extent you're asking a question about, a quandary your client might face, you want to make sure to anonymize that client information so that there's not any risk that it could be tied back to your client. If we could go to the next slide. In terms of the duty of competence, it's appropriate to use generative AI outputs as a starting point for research, as a starting point for analysis, but it should never be your endpoint. And those results need to be carefully scrutinized. And under our duty of competence, it's required that we are ultimately the ones that do the analysis. That's particularly key because it is possible that generative AI outputs could include information that is false or inaccurate or biased. And as Katie Lynn flagged, we've all heard those horror stories of someone showing up to court with a case that doesn't exist. I don't think any of us want to be that lawyer. Next slide. In terms of the duty of supervision, it falls to managerial and supervisory lawyers to establish clear policies regarding the permissible uses of generative AI and to make reasonable efforts to ensure that the firm adopts measures that give assurances that the firm's lawyers and non-lawyers' conduct complies with their professional obligations. And, I've just highlighted some of the key data, or excuse me, the key provisions in the California guidance, but this is truly a non-exhaustive list, and I really do encourage everyone to take a look at it. Go next slide. And so finally, key takeaways. Do not put confidential, privileged, or non-public information into chatbots. If you use AI for legal work, do so with extreme caution and full duplication via other means. You cannot delegate your professional judgment to generative AI. Law firms and managing lawyers should ensure that they set policies and conduct trainings regarding the appropriate use of generative AI. And last but not least, keep in track of developments and guidance because things will change very fast. And I think that's all we have for you right on the hour. Does anyone have any questions?